out of the control of the will. Also, other assets, such as retirement accounts like IRAs, 401ks, because those are set up in their own trust or custodial-like arrangements, you are able to name direct beneficiaries on those accounts, and whoever is named as beneficiary or beneficiaries, upon death, the remaining monies is paid out to the named beneficiaries. Same is true with life insurance or annuity products or other life insurance products. Whoever is named as the beneficiary or beneficiaries, that's how it pays out. And it is important to remember that the will does not come in and override or supersede a direct beneficiary designation. Instead, you have to think of the will as being a catch-all to what is left over. Quick example, I had a guy that came to me a while back and he said, Len, I want you to draw up a will and I want to leave 10% of everything to my church. Okay, great. I said, I can definitely do that. But understand, the will doesn't control all of your assets, because he had a 401k, he was an engineer, he had some life insurance and so forth. And as a result, if I just drew up a will saying, okay, 10% goes to his church, that would not include the 401k and it would not include his life insurance money. So to make a long story short, what we did there is he ended up and had what he wanted, the equivalent to go to his church, come out of his retirement plan, because that was pre-tax money. So it was kind of a win-win situation, because by doing a little bit of planning, and certainly the financial planner that's following after the break can probably get more into matters about the financial tax planning. But he was able to leave the church money directly out of his 401k, which meant that if he had left it to, say, an individual, well, they would have had to pay income taxes on the IRA because it's tax deferred or pre-tax. But because it went to a nonprofit organization such as a church, the church got the full amount. The only loser in that event was the IRS. So a little bit of planning goes a long way. Okay, so that is the will. Then we get into a power of attorney. Very important document to have in place. And a power of attorney is created by the principal. The principal is the creator, who is the grantor or the giver of the power of attorney. They give power of attorney to what is called an agent or the attorney in fact. That could be a spouse, it could be a child, it could be a trusted friend, or it could be an elder care specialist such as Rob, where under a power of attorney, they have the ability to act on behalf of the principal and handle their legal and financial matters. The main attraction with a power of attorney is that it will avoid a guardianship proceeding through the courts. And a guardianship proceeding, it's a very lengthy, ongoing, involved, often expensive proceeding where you're having to get court permission to basically do anything on behalf of the person, on behalf of the ward. The way to get around that is to have a valid power of attorney in place. And the way it works in Florida is that power of attorney is good from the time that the principal executes the power of attorney, and it remains in effect until either the principal dies or revokes the power of attorney. So it does lapse at death. In some respects, it's a mere opposite of a will, because a will has no legal effect while the person is alive. It's only after they pass away. But the power of attorney is fully revocable. That is the good news, so nothing is etched in stone. And I've had many people who have, they've given their girlfriend or their next door neighbor or some relative power of attorney, and they decide down the road for whatever reason they don't want that person to have power of attorney anymore. They can execute a revocation of that power of attorney, dissolve it immediately. And with the power of attorney, probably the biggest question I'm asked is people will say, Len, now if I sign a power of attorney, am I giving up any of my rights? And the answer to that is no, because what is not happening with the power of attorney, the person is not saying, I hereby give and transfer my rights to so-and-so, but instead you have to think of the power of attorney as being a coextensive extension of a right, where the person is saying, this individual, in addition to myself, can act on my behalf. And I have many people who have a power of attorney in place who are well into their 90s and they're doing very well, but they enjoy having the power of attorney in place because If they have a situation, say at the bank, they can say to their son or daughter who has power of attorney and say, you know what, I don't feel like going down to the bank and taking care of that. Can you go down and take care of that for me? They can do it. And certainly a power of attorney is in place if a person is incapacitated. And because otherwise, if there's no power of attorney in place, and let's say a parent is incapacitated and that son or daughter tries to do things on their behalf, they're going to run into a brick wall because they have no legal authority. Their only other option then is to hire a lawyer, go to court on what is called a plenary guardianship, and have to go through the full 9 yards of guardianship proceedings. So having a power of attorney in place solves many problems. And also, powers of attorney, especially in the last couple of years here in Florida, have become very specific. You know, it used to be we could write a power of attorney and say, I hereby give John Smith power of attorney. They can do the following acts and kind of give a general laundry list of what they can do with the power of attorney. That's basically all gone by the wayside. Now it has to be pled with great specificity. It has to refer, for example, to Florida's banking transaction statute, and Florida's investment transaction statute. And if these things aren't in it, these institutions don't have to honor the power of attorney. And this is the problem that we run in when people will come in and say, well, you know, I've got a power of attorney from Michigan. Well, can I use my power of attorney here in Florida? It doesn't work that way, because an out-of-state power of attorney, they're not going to have the foresight to say, well, hey, this person might move to Florida. We better have all these Florida state-specific things in the power of attorney. And so we run into this problem with LegalZoom. People are like, well, you know, I can get documents on LegalZoom. The problem is they try to make their documents legal in 50 states and they end up really not legal hardly anywhere because of that. And people will say, hey, you know, you're a lawyer, you're just looking out for yourself and other lawyers. Well, the truth is, you know, I want to make sure people have these documents in place, because the time to find out that your documents don't fly is not when a person is incapacitated and you have family members trying to act on your behalf. The truth is, when people come to me, and if they don't have the money, I have done plenty of work at a reduced rate, or I've done plenty of pro bono. I don't say that to pat myself on the back, but I want to be able to sleep good at night, know that I have done my best and that I have served the best interest of people, and I want to make sure that they have these documents in place, because an ounce of prevention is worth a pound of cure. And certainly that is true with powers of attorney. Then we get into the medical side of things, and we actually have two documents. We have living wills, which is the nickname of a document by which a person can make a declaration saying, in the event they have a terminal condition, no hope, no chance medically that they can ever come out of it, the living will makes that decision to pull the plug, remove the life support, allow the person to die with dignity. It avoids a Terry Shiloh situation. Now, that was the woman in St. Petersburg who was clinically dead for well over 10 years, but her organs were forced alive by life support. If she had a living will in place, all of that fighting, all of those problems could have been avoided, because everybody was speculating on what her intentions were. A living will takes care of that, has this spelled out in advance. With living wills, we can even be specific with what are called the 5 wishes. We can have the person say, well, if I'm in the end stages of life, there's no chance of recovery. They can say, well, in that event, I don't want to be placed on a respirator, or I don't want surgery, or I don't want medication that I'm for comfort and pain. It allows to have the person's end of life decisions memorialized and ahead of time, so they do work well. Florida has a very stringent checklist when it comes to diagnostic procedures before the person can be determined to be in the end of life stage. Also, 2 physicians have to certify that the person is in end of life, so nobody's going to be quick to pull the plug. In fact, it's usually very much the opposite. So that's a living will. And then finally, we have designation of healthcare surrogate. This is a document that sometimes people refer to as a medical power of attorney. In Florida, we call it a designation of healthcare surrogate. This allows for someone to appoint another individual to be their surrogate or proxy when it comes to making healthcare decisions, giving consent for medical treatment, and also allowing them to be able to access medical records and receive medical information under HIPAA. With the privacy laws, they're all scared of letting out any information. It's very important to have more than just a boilerplate form for a designation of healthcare surrogate. It needs to have specific information dealing with HIPAA. It also needs to have information or have where the giver or the grantor is granting the surrogate the right to make mental health decisions and mental health treatment, because what we are finding more and more is that medical providers, when it comes to Alzheimer's and memory disorders, they want to classify that under, quote, mental health treatment, and if the designation of healthcare surrogate does not give sufficient mental health care powers, they don't want to honor the designation of healthcare surrogate. So there's a lot of traps and a lot of considerations that these things need to be done right. Do I have any time left? Do I have any time for questions?
2 minutes.
Okay, any questions? Yes, ma'am.
My mom was a legal secretary, thank the Lord, so she had all her documents in hand. But I still ran into problems with the durable power of attorney because of her having dementia. We could not rewrite it to come up to today's standards. It was 2004.
Mm-hmm. And we've had in 2011 and in 2013, the Florida legislature made some major changes. So the good news is, because we had all this major overhaul of the law, the odds are it will be probably another 10 to 15 years before the legislature really changes things around again, because we find that usually about 10, 12 years on average is what it takes the legislature to make the rounds to monkey with these different areas of the law. Yes, ma'am.
You mentioned about changes to the power of attorney. How recent? We have power of attorney, but they're at least 10 years old.
I would recommend doing that. Now the statute, the last time, the legislature does have a statute where, to a degree, it tries to grandfather in existing powers of attorney, and we have found that in some cases that grandfather clause works, and in others it doesn't work so well. And for a precaution, especially if someone is getting up there in age and there's some concern that there could be some dementia or some medical issues, it's important to have the latest and the greatest as far as these documents in place. I thought I had a question on the left.
You got one last question.
One last question. Yes, ma'am.
Husband and wives need each other's power of attorney documented, or desirable?
Yes, because it's not always automatically, because you can have spouses who are still married in name only and be estranged from each other. So when it comes to legal, financial matters, healthcare matters, that should be pointed out. And certainly it's good to have a primary where a person is, say, naming their spouse, to have those powers and responsibilities, but it's also important to have a backup name, because what happens if the husband and wife are traveling together and they're both injured, both incapacitated? Who would step in upon death or incapacity of the other spouse? So it's important to have a succession plan spelled out within the documents. And I am out of time.
Thank you.
Nope, we're good, we're good. And a question for you, Lenny, put you on the spot. If Mr. Waring and his wife wanted to come talk to you, is there a fee for an initial consult?
Generally, on estate planning matters, no, there is not. Initially, I will sit down for a half hour or an hour if necessary and talk and go over those things.
Okay, thank you. Lisa and I, we're both guardians and case managers, and y'all don't want to see us as a guardian, because that's 5 to 10 to 20 to 30 to, I've seen it as high as $100,000 in fees, legal fees. So you guys want to make sure that